We have just about 16 minutes.
Thank you for your attention tonight. My name is Mitch. My answer is yes.
In addition to what you wish to share with this board, do you have any evidence or information that would indicate the application would violate the Yankton County zoning ordinance if approved?
I do.
Thank you.
My name is Mitch Petersen. I'm an attorney at the Davenport, Evans, Hurwitz & Smith law firm in Sioux Falls. One of my primary practice areas is zoning, predominantly CAFOs. I have been involved in probably 20 of these in the last 5 years. I think every zoning decision from our South Dakota Supreme Court over the last 5 years have been my cases. I've been before probably 2/3 of the counties East River. So I've seen a variety of ways of how things are done. And I have quite a bit of experience. I'd like to share that with you because it's readily apparent that the process here just doesn't comply with the ordinances. And their application doesn't. And ultimately, it's not about what you as board members have done wrong. It's not a criticism of you. It's an issue of have the applicants met their burden. It's their job to make sure that they give you the information to prove that the ordinances are met. And if they're not, you just can't say yes to it. Even if you want to for economic reasons, there are rules that have to be followed. And it is the applicant's burden to prove that. So it's really about whether they've met their burden tonight. It's not about you in particular. In particular, under Section 1905, Subpart 6, this is the conditional use permit regulation that's applicable to Board of Adjustment proceedings. That's what we're doing tonight. It's the conditional use permit decision. A building permit is a separate process. They could build this hog confinement facility and use it to store hay. But if they want to use it for hogs, they need a conditional use permit to do it. So that's why we're here tonight, to find out have they satisfied the burden of proof. And under 1905-6, it says before any conditional use is issued, the Board of Adjustment shall make written findings certifying compliance with the specific rules governing individual conditional uses. Those are found back in Article 5 that deal with CAFOs. So this thought about we don't need our details, we don't need to give you our engineering report, which I've seen, an engineering report is typically between 90 and 120 pages long. Every single Board of Adjustment I have ever been in front of in the last 5 years has those on the night you're doing this. And it's been available to the public for study for at least 10 days, which is not nearly enough, but that is minimally compliant with due process. They have the cart in front of the horse here. They absolutely do, because your time to determine whether your conditional use requirements in Article 5 are met is tonight. It's not later when they want a building permit. Because if you say, now we want to go back and look at this, they're going to say, tough, you had your chance back on July 5th to take a look at it. And if you deny it based on that, you're going to get sued. So tonight's the night to look at it. And it's not for DENR to look at county requirements. DENR looks at exclusively Clean Water Act compliance and water regulations of the state. They do not look at air quality at all. They will not look at odor. They will not look at anything other than water, because it's a water discharge permit. That is the only thing that they do. And additionally, as their engineer, Mr. Warner, stated, often county requirements are more stringent. They're stricter. They're harder to meet than state requirements. But you know what DNR does if their requirements are met but the counties aren't met? They grant the permit, because it's their job to deal with state regulations. It's your job to deal with county regulations, and that time is tonight. A bit about risk. That's what lawyers do. We deal with risk all of the time, and that's what all decision makers do. You have virtually no risk in saying no tonight, because you might collectively have 10 different reasons why you shouldn't grant this permit. It's not good for the economy, it's not good for air quality, they're missing different, whatever it is. Say you've got 10 of them. If they appeal to a court and the court says, you guys were off base on 9 of the 10, but you're right on one of them, you know what happens? The court says you made the right decision. On the other hand, if you grant this permit and we appeal, and we will, and I've done it all the time, I'm used to doing it, and have a petition out in 48 hours. If we put up 10 reasons why you shouldn't have granted the permit, there's 10 different reasons why you had no authority to do this, we only have to win one in court. Only one. So there's a lot less risk in saying no tonight. You've got a lot of shade and a lot of cover based on how the law works. Additionally, you avoid liability with unconstitutional takings, due process issues, Section 1983 claims, nuisance claims, reimbursement claims from farmers who's now has, junk on the fruit that's going into schools. You avoid all of that liability. A bit on how the ordinances work. Article 5 are your CAFO-specific control requirements. These are the things that only apply to CAFOs. There's all sorts of other conditional uses, but it's Article 5 that deals with CAFOs. Article 19, and in particular 1905, is applicable to all conditional use applications. So whether it's a CAFO or any other thing on that list, there are other things that have to be met. So if the applicant hasn't done their job of putting an engineering report on your desk that shows detailed compliance with everything in Article 5, you can't say yes to it. I mean, under your ordinances, that's just not within the authority that Yankton County Commission has granted to the Board of Adjustment. You have to say no. But even if they've met all of those requirements, you still have a decision to make under 1905. You have a decision to make. You may grant it, but you aren't required to grant a conditional use permit just because Article 5 is satisfied. 1905 requires the exercise of discretion and judgment. Is this the right idea for the community? Specifically under 1905 6H, you have to decide, even if all of the specific CAFO requirements are met, is this generally compatible with the neighbors and the adjacent properties? And particularly, is this in the public interest? So I'd submit to you, you've got an important judgment call to make tonight, even if you believe all of the CAFO-specific control requirements are met. You don't just turn your brain off then. Now you're making a decision for all of these people out in the room and all the other people in your community of what's the right decision, what's the right policy decision. And you say no on that basis, you're never getting reversed by a court, because the court's not going to reweigh whether you made the right decision and weighed public interest correctly. That's inherently within your discretion to make that decision. On to the specific merits of Article 5 and the CAFO-specific control requirements or performance standards. Again, under Section 105 of your ordinance, it says that every rule throughout the entire ordinances are minimum requirements that have to be met. Minimum requirements. So that's important to think about when we get to Article 5. In particular, the fact that 6 out of the 7 applications have requested a variance conclusively demonstrates they do not comply with the requirements. Otherwise, they wouldn't be asking you for a variance. That is your proof right there on the next 6 barns that are coming up. That they're asking permission not to follow the rules admits that they're not following the rules. It's that clear. Otherwise, they wouldn't be asking for permission. Number 2, under the definition of an animal feeding operation in your ordinances, what class are these CAFOs? Are they really Class E? Because under the definition for an AFO, animal feeding operation, if there's commonality of ownership within a mile, then they have to be considered one CAFO if they're within a mile, and that is the case for some of these. Additionally, even if they're not more than a mile apart, if they have a common area for manure disposal, they are considered one CAFO. Even if all 7 of these, if they're using the same system, same manure hauler, and using the same contracts, you have to consider them as a whole. Your ordinances say that. And you haven't been given the details about what their manure management plan is to know whether you count them together or not. I don't know how you're supposed to do your jobs when they haven't given you the documentation to do the important work that you need to do. It's not your fault, it's their fault. They didn't do the work that they needed to do. They got the cart in front of the horse to try to float this idea out, which I think is pretty telling about the level of diligence and attention to detail they may provide as operators once these things are up and running. So I'd submit to you that your very first job of determining which class it is, so which rules are we looking at, you can't even answer that question based on what they've given you. So you got to say no for that reason. Say come back when you've got your ducks in a row. Number 3, there's no engineering report. Again, this is completely unprecedented to have no engineering report at the conditional use hearing. I've never seen it before. And it's required. Under 519, Section 10, a facility management plan is required at this point in time. 519.10 requires it, and it has a bunch of stuff that has to be in it, including what is their system for manure collection, storage, and treatment? Why would that be on there? To determine whether you count these together or not. I mean, that's one reason why that's part of what your facility management plan requires. They have to explain how they're handling dead animals, what they're doing for screening and buffering to try to control noise, glare, odor, flies. They have to provide information to you about the prevailing winds. I've yet to see a CAFO application that doesn't have an odor footprint study. You know nothing about where the odor is going to drift. You have to have that and know about prevailing winds and topography in order to make a site-by-site and site-specific decision about what additional controls may be required. They haven't given you the information to do the important work that you need to do tonight. Additionally, that facility management plan needs to have within it information about the topography, stormwater management, manure removal and application to make sure that they're meeting the manure application setbacks, which is different than where the CAFO itself can be located. There needs to be industry best management practices included. They don't have that. And there needs to be information about climate and weather information. They don't have any of that. It's required under 519.10. Additionally, under 519.7 and 5, it talks about various setbacks that are measured from the CAFO structures to various things that would be surrounding it. We don't have information about where those are. To measure from point A to point B, you got to know where point A and point B are. And they haven't provided the information about where their structures are. I'd submit to you, there's no possible way they could prove that they've met the setbacks. And I was at the auditor's office this afternoon. I was told there's been nothing else new, and now we find out maybe there's some other site plans to which the public had precisely zero access to even read, let alone study, formulate thought, and come here, prepared to oppose it. That's a due process violation right there. That's a slam dunk up here. Again, who is running the operation? Section 520 of your ordinances state that if any application is being sought with the intention of transferring ownership, control, operation, that itself is, you have to deny it for that reason. You need the real person who's actually be running this to come here to look at you and answer your questions. How is it that 7 of these somewhat unrelated people all have the same lawyer, the same engineer, all at the same time with exactly the same footprint? What is the story? And I'd suggest to you, we don't know the story. For that reason, you've got to say no. I do want to talk about variances. I can save that to later because I know I'm nearing the end of my time. But I would ask the comments I've just made, will they be considered for all 7 hog barns? Good, I appreciate it. Would you like me to address variances this time, and then I can, in all likelihood, stop talking for the night?
No.
Okay, I'll wait to do it. All right. Appreciate it. Thank you.
I would entertain a motion to go to executive session.
Wasn't on the agenda though, was it? No. Wasn't on the agenda, was it, Don?
No. No. No.